You guys wake up out there, because we got something a little controversial this week. In fact, I'm going to preface this one by suggesting that before you do anything based on what we're going to talk about the next few minutes, you check with your command personnel and see what they want to do. And they may want to check with their civil legal advisor or your local prosecutor. Remember, I don't set policy for you. I just want to tell you what tools are out there if you choose to use them in your jurisdiction. It's up to you. This has to do with questioning outside Miranda. Should you do it? When should you do it? What if you do? What if you don't? You've got somebody in custody and you Mirandize him and he invokes. Either way, he says, I want a lawyer, or I want to remain silent. Whichever way he does it, he shuts you down. What should you do? Should you just stop, fold up your papers and walk away and say, well, that's that? Or should you say, well, okay, so you want a lawyer, you want to stop talking, let's go ahead and go off the record and talk anyway. Should you do that? You probably should not do that if you're going to be holding on to the guy for a while, because he may change his mind. He may change his mind before you go outside Miranda. Give him a chance to sit and stew in the cell for a little while and see if he changes his mind. Let's say you pop him and you're going to be holding on to him overnight before you take him over to county, or maybe he bails out of your own jail or something, but you're going to have your hands on him for a while. He's going to be with you for a while. The better thing probably in those cases where he invokes is to just give him your card with your phone number on it and say, okay, call me if you change your mind, and then walk away. Let him sit and think it over. Let him go back to the cell and stew for a while. And maybe then he'll think up a story that he thinks he can sell you. And so maybe then he calls you back and says, hey, get that detective back, get that officer back I was talking to, I want to talk to him again. And then, if that should happen, then remember, we've already talked about this once, Oregon versus Bradshaw, the U.S. Supreme Court said that's okay. If he reinitiates, if you honored his invocation to remain silent and he then reinitiates, that's okay if you take a waiver of the right that he had previously asserted. So when he calls you back and says, hey, I changed my mind, I do want to talk after all, sit down with him and say, okay, then do you mean now that you want to waive whichever one he had invoked before? So if he had said before, I don't want to answer any questions, then you say, okay, now are you saying that you want to waive the right to remain silent after all, and you do want to talk? Yes. Okay, let's talk. No need to re-Mirandize him. People versus Brasicki, lots of other cases. You don't need to re-Mirandize him. He already knows his rights, and he's proved that by asserting them. So, but you do need to take a waiver of the one that he had previously invoked. So if he previously invoked right to an attorney, for example, and then he calls you back 2 or 3 hours later and says, oh, I changed my mind, I do want to talk to you, then you should say, okay, then are you saying that you want to waive the right to have an attorney and go ahead and talk to me by yourself? And if he says yes, rock and roll. No need to go through the whole new Miranda thing again. Now, that's in those cases where you're going to have a chance for him to reinitiate. What if you've got a guy that you've only got one shot at? This is it, it's now or never, because you're going to lose him. He's going to bail out, or a lawyer's on the way down there, or you're going to have to take him over and give him over to some other officials. You're never going to have another chance at this guy. This is it. And you Mirandize him and he invokes. What you can do, legally do, in that instance, is go outside Miranda and continue to talk to him, because you've got other legitimate purposes in talking to him other than obtaining an admission of guilt that could be used in his trial. And that's what Miranda protects him against, you compelling him to make a statement that is later used in trial to convict him of the charge. But you may want to go outside Miranda and get information to help you clear cases. If you want to clear paper on a bunch of cases that look a whole lot like the one you popped him on, and you think this is your chance to do it, it's true his statements will not be admissible in court on those cases, or on this one that he's talking about. His statements won't be admissible in court, but they'll help you close some files out of the file drawer. Go right ahead on. Or maybe it'll help you recover a dead body or a missing person. If he's kidnapped or killed somebody and you're still looking for a body, go outside Miranda if he invokes on you, and you're not going to have another chance to talk to him, and see if you can recover a body for some bereaved family. You may be able to recover stolen property. He tells you where the property is ditched. His statement will not be admissible against him in trial if you go outside Miranda, but you'll get the property back and the owner will get the property back. That's a legitimate function. Maybe his statement outside Miranda will reveal methods his methods of operation, how he was able to obtain these credit cards and how he was able to pull off this scam or whatever. So sometimes use it for G2 to get yourself some intelligence. Go outside Miranda, take his statements, knowing you're not going to be able to use them in trial against him, but you are going to be able to use them to figure out how this guy operates and how other criminals like him operate so that you can do a better job of shutting them down next time. Maybe his statement will identify other criminals that are capering in your community, sources for whatever it is he's doing. If he's doing drugs, maybe he'll give you some kind of a line on a connection. Fences, if he's fencing stolen property, maybe he'll finger the fence for you. Locations where crime is going down. So you use it for all this intelligence information, even though the statements wouldn't be admissible in court. He may reveal the existence and identity and location of other accomplices that he had in this crime, and we may be able to go and arrest them, or other witnesses on the case, and we may be able to track them down and get them to come in and testify. Or his statements might reveal the existence and the location of physical evidence. You've got him, but you'd kind of like to have the gun that he used or the knife that he used or whatever else it was, but he ditched it somewhere and you can't find it. And so you've arrested him, he's invoked Miranda, and you say, well, I'd still like to find the evidence in the case. So you go outside Miranda, and if he talks outside Miranda, if the only thing that was shutting him up was the chance of it being used against him in court, and then you go outside Miranda and take a statement, and then he tells you where the stuff is, we can go and get all that evidence. And it forces the defendant to commit to a statement that will prevent him from pulling out some defense and using it at trial that he's cooked up with some defense lawyer that wasn't true. So if you get a statement outside Miranda and he tells you that he did it, how he did it, or even if he gives you a denial of some sort, he's tied to that. He is married to that because the U.S. Supreme Court in Harris versus New York and the California Supreme Court in People versus May have told us that we can use statements outside Miranda to impeach or to rebut. We can't use them for our case in chief. The DA can't trot them out to the jury before he says, I rest. But if the defendant then gets up there and gets on the stand and lies and says something different, we can use his outside Miranda statements to impeach him. We can use it to rebut his case. Perfectly legitimate, said both the California and U.S. Supreme Courts, to use non-Mirandized statements if they're otherwise voluntary. I mean, we can't use them for any purpose if you beat them out of him, but if they're voluntary statements, the fact that they weren't Mirandized will mean we cannot use them in the case in chief, but it does not mean we can't use them to impeach or rebut. So you see, you got all those legitimate purposes that could be served by statements taken outside Miranda. Let me back up for a second because you may have raised an eyebrow when I ran across a couple of these. I said, maybe he'll tell us about other witnesses or the location of physical evidence and we can go and get that. We can use those witnesses against him, said Michigan versus Tucker. The U.S. Supreme Court said, even though you only discovered that there was a witness because you took a statement outside Miranda, the witness can still come and testify. All you lose under Miranda is the defendant's own statement. The Miranda exclusionary rule is limited to the defendant's own statement out of his mouth. That is all that is excluded under Miranda. It doesn't have a fruits of the poisonous tree theory attached to it the way constitutional violations do. When you violate Miranda, you're not violating the Constitution. Miranda is not in the Constitution. It's a court-created decision that affects the admissibility of testimonial evidence, and that's all it is. So you don't violate any law. There's no law says you can't question people outside Miranda. You don't violate the Constitution. The Constitution doesn't say you have to do that. It's a court decision. So all you're violating is a court decision controlling admissibility of evidence. So you're not doing anything unlawful. You're not doing anything illegal. You're not violating anybody's civil rights. You're doing nothing improper. The only consequence of your talking to somebody who has invoked his rights is we will not be able to use his statement in the case in chief in trial against him. But it doesn't have the consequence of excluding fruits of his statement. Oregon versus Elstat from the U.S. Supreme Court, and a bunch of federal cases and some state cases, too numerous to show up here on the screen, but I've listed them for you in this week's syllabus. A lot of cases have said the fruit of the poisonous tree derivative products doctrine does not apply to Miranda violations. All we lose is the statement taken in violation of Miranda. We do not lose physical evidence that resulted from that. We do not lose the testimony of other witnesses that we learned about only by violating his Miranda invocation. Now, some people worry, gee, if I question a guy outside Miranda, Won't I get prosecuted myself? Won't I go to jail for doing something illegal? Won't I get sued in civil court for violating his civil rights? Well, just ask yourself, have you ever seen hundreds and hundreds of published cases where a court found a Miranda violation? Hundreds of them on the books where courts have found Miranda violations. Did any of those police officers get sued? Zero. Did any of those police officers get charged with a criminal offense? Zero. None of those police officers who should have Mirandized somebody but didn't, who thought they were asking clarifying questions and the court later held it was interrogation, who didn't think that Miranda applied but it really did. None of those police officers who has made what the courts later found to be a Miranda mistake has been sued over it, has been filed on in criminal court over it. There's nothing illegal about continuing to talk to somebody. It simply has a consequence, an evidentiary consequence in the case in chief and trial, that we cannot use that statement. It does not have any penal consequence for you. You're not doing anything unlawful. You're not violating any statute. You're not violating the Constitution. You're not violating any civil rights. You're not incurring any civil liability. All you're doing is limiting the admissibility of evidence. You're limiting it to the impeachment and rebuttal phase of the trial, but you can accomplish all of these other legitimate purposes that don't have anything to do with the prosecution of the case, and some that do, by talking to the guy outside Miranda. So whether you do it is up to you. I don't tell you what to do. Can you do it? Sure you can. All of these cases have said there's legitimate uses that a Miranda violative statement can be put to. The only use it can't be put to is to prove the person's guilt in a trial. But it can be used to prove that he's a liar when he gets on the stand and tells a different story. It can be used to discover other evidence that will prove his guilt in trial, okay? So you may want to consult with folks there in your department, maybe your local prosecutor, to see if they have a strong feeling one way or another, but you're up to date on what the law tells you about going outside Miranda. I'll see you next week.